challenges of the appointment of the arbitrators. May I have the honor of the chair and the speakers for this session to please come onto the stage. We have with us Justice L. Nageswara Rao. Justice Rao was the 7th judge to be elevated directly from the bar after having worked as an advocate for almost over 30 years. He was part of 555 benches and delivered over 160 judgments during his tenure, which saw him passing some crucial verdicts over the course of almost 6 years. He enrolled as an advocate with the Bar Council of Andhra Pradesh in 1982 and practiced at the Andhra Pradesh High Court till 1994. He shifted his practice to the Supreme Court in January 1995 and continued till his directed elevation to the bench in May 2016. He's currently an associate member of 39 Essex Court. With Sir, we have our esteemed panel of speakers, Professor Dr. Hoss. She is the Director General of LCIA since 2014. She continues to sit as an arbitrator and handles cases under ICSID, ICC, LCIA, and UNCITRAL rules, as well as those under the Netherlands Arbitration Institute. She is also involved in setting up the arbitral process for the Claims Resolution Tribunal in Zurich. She's the Professor of Arbitration Law at the Leiden University and a member of GAR's editorial board. Moving on to Mr. Aggarwal. He is now a partner and head of India practice at Three Crowns LLP. He's a dual qualified English solicitor and Indian advocate. He has extensive experience of representing clients in both commercial and investment treaty arbitrations across a broad range of sectors and in arbitration related to court litigation. Mr. Aggarwal is consistently ranked as a leading practitioner in arbitration and public international law by major directories such as Who's Who and the Legal 500. Next, we have Ms. Petit. She's a partner, head of international arbitration and head of India practice at the Stewarts Law. She specializes in litigation and ADR across a broad range of industries. In addition, she regularly sits an arbitrator in international arbitrations, is a published writer and a speaker on international arbitration, and is an expert on India-related matters. She is on the board of LCIA, the LCI Remuneration Committee, the ICC Indian Arbitration Group, SIAC Users Council, amongst others. We also have with us today Mr. Desai. He is the managing partner of DSK Legal since it was founded in April 2001. Recognized as a leading practitioner in India, Mr. Desai has over 30 years of extensive domestic and international experience, being trusted counsel to several large multinational and Indian corporates. He has served as a national president of the Indo-American Chamber of Commerce and has also served and continues to serve on various committees. We welcome you all. With this, I request the chair to please take the discussion forward.
Good afternoon, ladies and gentlemen. I hope you had a good lunch. And I see that the seats are empty. Most of them are still having lunch and doing some networking. But as we have to start on time because there is another session after this, we will proceed with the session. I have a distinguished panel speaking on a very important aspect of selection and challenges to arbitrators. I don't wish to speak too much at present because I'll be stepping on the toes of the speakers because most of the topics are going to be covered during the course of this discussion. But one aspect to kickstart this session is this. India is a sui generis jurisdiction insofar as appointment of arbitrators are concerned. Everywhere in the world, you see institutions making appointments of arbitrators. Here in India, the majority of arbitrations are ad hoc arbitrations, and it is the parties' autonomy to select arbitrators. And more often than not, they do not agree either on a sole arbitrator or the presiding arbitrator after nominating their own arbitrators, and the matter lands up in court. So you would see most of the arbitrators being appointed under the Act by the High Court. And insofar as international arbitrations are concerned, it is the Supreme Court which makes the appointments. Delhi High Court, which has taken the lead in having this Delhi Arbitration Weekend. This is the second edition, and I've been speaking to my fellow panelists who are very impressed with the way this seminar or conference is being conducted, and there are a number of people from beyond the shores who take a lot of interest, and then they meet so many people. They hear speakers talk about the arbitration in India and then what is to be done and what has been done. The Delhi High Court, which takes the lead, is also very commercially friendly insofar as petitions filed for appointment of arbitrators is concerned. But there's a major problem in the other parts of the country where applications for appointment of arbitrators are stuck for a few years. That's where the problem starts. So after the court takes a call for appointment of arbitrators, things are not taking that much time in completion of arbitrations except for in a few matters. So selection, which is being done by the high courts, I just want to make one comment. I only see one judge here, Justice Subramani Prasad, and I hope he would also convey this concern of an arbitrator to the other judges of the high court. The appointments that are made by the High Court is after taking into account the consent of the parties, and insofar as presiding arbitrator is concerned, they have a panel, or otherwise they appoint either Supreme Court judges who are retired or the High Court judges who are retired. One problem that is arising is that the retired judges or even the other arbitrators who are appointed are not spoken to before appointments are made. Let us take my case. I've been appointed by the Delhi High Court in a few arbitrations, and then I would only know when I receive the order that I've been appointed. There might be a case of conflict. I would have appeared for one of the parties. I might be having a problem of independence. I would be having other problems where there is a disability from appearing because I have too many matters. So if I have to convey that, and again another person has to be substituting me, that's going to take some time. So this is something, if it is taken care of, that also will take care of a small problem of the High Court asking the counsel to go back to the arbitrator and ask him whether he would be willing to take it up and whether he has the time to take it up. That would be much easier. Other than that, the applications that are filed for appointment of arbitrators in the Delhi High Court, the speed at which they are disposed of, I think is tremendous, and then it leads the way, and the other high courts also have to follow suit. That would really reduce the time in appointment of arbitrators. As you all know, the selection of an arbitrator is pivotal to an efficient arbitration. It is the arbitrator who takes the lead in ensuring that the arbitration is conducted in a smooth manner, apart from being efficient. What is it that the parties are looking for while appointing an arbitrator? They want an arbitrator who's impartial, who's independent, who's also efficient, who can also manage people well and ensure that the arbitration is completed on time. These are certain basic things which people see when they want an arbitrator to be appointed. All the other aspects which are revolving around the appointment and selection will be discussed during the course of this session. I would start with Jackie's views on the LCIA's practice of appointment of party-nominated arbitrators. When the LCIA is called upon to confirm parties' nominations or to make default appointments, what is it that you look for?
Is it working? Yes. Thank you very much. Thank you very much. And thank you to the organizers for the opportunity to contribute to this panel and be part of this wonderful arbitration weekend. I love the idea that the weekend already starts on Tuesday, but it is a great pleasure to make the weekend a bit longer if it allows us to have these kind of discussions. So I was asked to comment on the LCA's approach, and before doing that, briefly to set the scene. Because indeed, there are different ways of appointing arbitrators, and we just heard about the practice in India with a lot of appointments in ad hoc cases being done by the courts. What we see in international institutional arbitration in particular is that there are really two flavors. One flavor is that the parties nominate, and either the party-nominated arbitrators choose the presiding arbitrator or the institution chooses the presiding arbitrator, or alternatively, all three arbitrators or the sole arbitrator are selected by the arbitral institution. And we heard yesterday in the opening remarks of Justice Monmohan that Jan Paulsen floated the ideas years ago that, I'm paraphrasing in a slightly suggestive way, but that party selection is overrated. Whether it was completely true then that party nomination was the only system, I rather doubt, but certainly now, party nomination is not the only system. And if you look at the LCIA, for instance, the default rule is that the institution appoints the entire tribunal. The default rule is, as the name says, a default rule. So if parties decide differently, if they put in their clause or agree subsequently that there will be party nomination, then that's absolutely fine. But in almost half of the cases in which the LCIA is appointed, the LCIA selects the entire tribunal. There are other mechanisms such as list procedures or rosters. That's something internationally we mainly see in institutions that administer quite specific arbitrations, whether grain and feed or insurance or other sector-specific arbitrations. So now turning more specifically to how the LCIA approaches a situation where in principle, there is going to be party nomination, and either the LCA needs to confirm the party-nominated arbitrator or the LCA needs to appoint somebody in lieu of the party because the party is simply not doing that. Well, the first starting point is the provision that deals generally with arbitrator appointments, Article 5.9, that says you need to look at the particular method agreed by the parties. So we assume that that, in this case, includes party selection. Then the LCA will look at the transaction at stake, the nature and the circumstances of the dispute, the monetary amount or the value at stake, location and languages of the parties, the number of parties, and all other circumstances that can be relevant. And other circumstances that you may want to think of that are not spelled out in the rules is, for instance, whether sanctions play a role. These days, that's quite a topical sanction, and different countries have different sanctions regime. So if you select a national of a particular country, the sanctions regime of that country will be implicated. Then you look at specific considerations, and in particular, the arbitration clause. One type of clause that we see quite frequently at the LCIA is a clause that imposes requirements on the qualifications of the arbitrators. Somebody must be qualified pursuant to a particular legal system or a member of the bar in a particular system. What we even see not infrequently at the LCIA is a requirement that arbitrators are barristers and King's Counsel, or some of the clauses may be old and refer to Queen's Counsel, but in any event, stipulating a particular level of seniority. And that's something which the LCA then will take into consideration. A key factor, which is not identified enough, I think, in this whole discussion about arbitrator appointment, is the applicable law. That is a key consideration for the LCA court in selecting any arbitrator, and I suggest also the parties. That doesn't mean that you have to have the nationality of that law, but typically the largest group of qualified people will be from the nationality of the law that you need to apply. Then there are negative considerations. So nationality is one. The sole and presiding arbitrator may not have the nationality of one of the parties. Conversely, where the LCA is involved in appointing in lieu of one of the parties, you will typically look at the nationality of the party for whom you are trying to appoint an arbitrator. A key consideration, and we're going to come back to that, is independence, impartiality, and availability. So I won't speak about that here, even though it is a key consideration, as our chairman already identified. What you do as an institution when you select in lieu of a party is kind of putting yourself in the place of the party. And you think not who would be an advocate for that party, but what are the type of characteristics, what is the profile of arbitrator that you are looking for? The LCA will look at the objective characteristics that I referred to just now, but also if somebody has already been involved in other cases. We tend not to select the same arbitrator more than twice a year. That's not fixed in the rules, but that is a practice which is fixed in our good practice manual, if you will. So those are the considerations that we look at. Applicable law is a key consideration, and you try to do as best as you can what you think the party would have done had they been the party making the selection. And a final comment, I said I would come back to independence and impartiality. We are more rigid when it comes to disclosure requirements when we are selecting for a party. So something where if a party is participating and an arbitrator makes a disclosure, we would sometimes put it to the parties and not necessarily see that as an impediment. Where we are selecting on behalf of a party, it is very difficult to work with any type of disclosure because you can never anticipate what the party who is not participating would have said about the disclosure. So we tend to be more rigid about disclosures when we select in lieu of a party. Thank you.
Thank you. Sherina, as a counsel, what are the factors that you would take into account in recommending a party-appointed, nominated arbitrator? And would it be different when you are making a recommendation for a sole arbitrator or a presiding arbitrator?
Thank you, Justice Rao. So I'm just in terms of timing, Manish and I were just discussing, I'm going to touch upon looking as counsel at appointing a party-appointed arbitrator, and Manish is going to pick up on
That
sole
will be better.
arbitrator.
That will be.
And then if there are some views, we can go through that between ourselves. So as the moderator of the session started the session by saying, it is universally acknowledged that in large part, the quality of arbitration, it depends on the arbitrator, the quality and the skill of the arbitrator. And the first thing is, when I'm looking at the selection and I'm acting as counsel, I try to work out the psychology of the other side. What is the goal of the other side, particularly if I'm claimant? Is the respondent going to try and frustrate the process? What games is the respondent going to play? And if they are not going to cooperate, they may just decide not to appoint their co-arbitrator, their party-appointed arbitrator, then we have to go to the institution. Or if they're just being very difficult, then the first thing I want to do is have an arbitrator who is going to be fair but firm, who's going to have real experience in steering this, because that's I'm going to have that sense right from the beginning. How difficult is this arbitration going to be? Is it going to be straightforward? Is it not? Once I've sort of bottomed that out, that's where I would look at, as I said, fair but firm. Flexible as well, but firm. The next thing I would look at is the clause. What does the clause of the arbitration dictate to me? Does it dictate the type of arbitrator that needs to be selected? Sometimes clauses say that an arbitrator needs to have a qualification like CIR. GAFTA sometimes requires parties to be GAFTA arbitrators. Sometimes clauses, I had to decline one because it asked for whether the arbitrator to be appointed had a particular skill. In the one that I was approached about, it asked whether I had cement expertise, and I didn't. And I declined that. And so, you know, you have to look at what the clause firstly dictates to you and be guided by the clause. Of course, sometimes parties agree to waive requirements in the clause, and that's fine if those requirements are waived, because of course when the clauses are drafted, one doesn't know exactly what type of dispute is going to come out at the end of it. I've seen clauses where parties have asked for in the clause that KCs be appointed, or particular, you know, that it has to be a judge of a particular court. So again, it's all dictated by the clause. Now, if the clause doesn't dictate it and leaves it to us as counsellors to decide, then the next thing I do is I look at the case and do a merits analysis of the case. And that dictates to me whether I'm actually looking at a black letter lawyer or actually someone who's more commercial. And that is something I will discuss with my client. Do I want someone who is, what is the type of case? What are the issues that are going to arise? Do I want someone who's going to read the letter of the contract? And is that letter of the contract in my client's favor or not? So do I want black letter? Do I not? Do I want commercial? Do I not? Do I want a holistic view? Do I not? And then again, I look at the relevant law and putting what I've just said again into consideration. Do I want someone who's actually qualified in that particular law, or do I not? Because that's the beauty of arbitration. And so again, you know, how is my case favorable with that law? Is it going to help me? Is it not going to help me? And if it's not going to help me, I don't want an arbitrator that's appointed for, who is conversant with that particular law. And then the next thing I do is I look at judgments. I look in the public domain. I snoop around, talk to colleagues to see if the arbitrator, the person I'm considering appointing, has written any articles on particularly thorny issues. For example, arbitrability, what are their views on that? So that again stems from the merits analysis. Because selecting your arbitrator is an art and a science. And it's so much is about psychology as well. And it's ultimately what's going to dictate your award as well. So you want to get it right. And people don't understand the art and the science of getting it right at the start. So I look around, I read judgments, I look in the public domain, I look at articles. And that's also going to dictate to me stuff from articles that I'm going to actually quote in pleadings, ultimately, if that person is selected. Because that view that I would have found is going to help me ultimately when I'm drafting my pleadings. I obviously look at the language, that they're proficient in the language. That's an obvious, because that's cost saving. And I do look at the cultural background, because ultimately you want everyone to understand the cultural background and the cultural gaps that are there, and to bridge those gaps, particularly because if the parties are very international. And again, if I am acting for the respondent, then I would already know the claimant's choice of arbitrator. In that sense, the person that I would select, I would want to know that that person's going to be compatible with the claimant's choice of arbitrator as well. They've got to be able to work together. And again, lots of stuff in the public domain throws out things about how people would have been working together. Are they dissenting judgments? Are they not? Of course, arbitration is confidential, but sometimes there's stuff out there in the public domain. And then there's something you touched upon, Justice Rao, about availability. Sometimes the big names in arbitration doesn't mean that they are available and are going to devote the time and the patience to go through the issues. Diversity is, again, a very big point that I do look at. And if I get a list from my clients of completely undiverse names, then I do push back, and I would consider saying, can you please consider putting 3 diverse names? Now, it's not because I'm trying to, sell women or sell age or sell race. It's because they're really good quality and they need to make it into that list. And finally, it's experience of case management skills and experience of handling a case. Coming back to the first point I made, how difficult is the case going to be? Do you really need someone with super experience? And again, one of the last points, but one of the most important points, and it's the point you made, Justice Rao, it's about integrity, impartiality, and independence. And the LCIA rules particularly make it a requirement that the arbitrator needs to be impartial and independent. And I think that is, the fundamental of what you are looking for, given everything I have said. Thank you.
Thank you, Sherina. What do you use, Manish, on this?
Thank you, Mr. Rao, and it's a pleasure to be here. I would really echo everything that Sherina said, particularly about selection of either your co-arbitrator or kind of the input you provide in terms of selection of a presiding arbitrator being an art and a science. When it comes to a co-arbitrator, as Sherina said, what you are really looking for is an individual who would respect the principles of independence and impartiality, but who may still be predisposed to deciding the case in your favor because of his or her profile, legal background, published views or approach to cases. Right, so you're really trying to balance those considerations in making your decision about a co-arbitrator. I would also echo what Sherina said about the importance of independence and impartiality. I think quite often you hear from the clients that they're really looking for somebody who's going to go and bat for you, who's going to be your advocate. And our advice to the clients often is that can be actually quite counterproductive. Particularly if you have a 3-member arbitral tribunal and you look at the dynamics of arbitral decision-making, if you appoint somebody who's so obviously partisan, who's going to always vote in your favor, that person's views may actually be dismissed by the most important member of the tribunal, the presiding arbitrator. And so therefore you run the risk of actually marginalizing your co-arbitrator on a tribunal if you appoint somebody who doesn't comply with the fundamentals of independence and impartiality. So you're looking for that substantive predilection in your favor, but at the same time somebody who has the requisite integrity, as Sherina said. So that is in terms of the co-arbitrator. Now when it comes to presiding arbitrator, as you know, Justice Rao, and as most of the people will know, most arbitration agreements do not really go into much detail in terms of the method for appointing a presiding arbitrator. Some agreements will say that it's the parties who will select the presiding arbitrators. Others may provide for the 2-party appointed arbitrators to choose a presiding arbitrator, failing which you go to either the arbitral institution or an appointing authority in the form of courts, where you're in the context of an ad hoc arbitration. I think in most of the cases we deal with, more often than not, both parties do not prefer to lose control on the process by going to the appointing authority, be it an arbitral institution or the national courts. I think the preference typically tends to be for parties to agree on a method or to kind of structure the process by which the two co-arbitrators will select a presiding arbitrator. And again, one method that we quite often use, and it appears to work well, it's not perfect, but it tends to work well in practice, is a blind strike and rank process. And what you would typically do in that is you will invite the co-arbitrators to present the parties with a short list, say, of 5 candidates. After confirming with those candidates, they're conflict-free and available, going back to the point you made, because you don't want to then have that inefficiency. And then you will build in a process for parties to convey any objections to the co-arbitrators, particularly in light of any disclosures that may be made or in light of any undisclosed facts or circumstances. Once you have your shortlist, then the parties may strike up to 1 candidate each and then rank the remaining in order of preference, and then the candidate with the best aggregate ranking is appointed by the co-arbitrators as a presiding arbitrator. Again, that system is not perfect, and we can have a debate around that, but in my experience, both parties typically tend to want to maintain some control over the selection of the presiding arbitrator when it comes to rather than leaving it to the default mechanisms.
Thank you. After my retirement, in one of my first arbitrations, I was appointed as an arbitrator by a party. And when the counsel for the party was arguing, I put a few questions to him which were inconvenient. In the evening, I got a call from the law firm which nominated me saying, "Sir, you're our arbitrator. Please don't be harsh on our counsel." So I had to tell them that you don't own me. You appointed me as an arbitrator and I have to be impartial. And during the past 1.5 years, having sat in various combinations, I find it really a feat as a presiding arbitrator to control my co-arbitrators when I see them trying to support the parties. Except in the New York State Code, where the party nominated arbitrator is permitted to be partial to the party who was appointed. Universally, it is accepted that even party nominated arbitrators should be impartial. There's no way they can say that I've been nominated and then I'm going to canvass their case. I will turn to Anand. Anand, in international arbitration practice, a party's counsel or a party is permitted to have ex parte communication or interview with the arbitrator who is going to be nominated by them. And even they have a say in the appointment of presiding arbitrators. In the Indian context, I want your views about the party's role or the council's role in approaching the arbitrators and interviewing them, finding out about their availability, about their expertise, etc., to start with. And the second aspect, I have 2-3 questions here. The second aspect is whether the party has a role to play in the selection of a presiding arbitrator, or is it left to the arbitrator who has been nominated by the party along with the other arbitrator to decide who should be the presiding arbitrator, and ex parte communications. So what is your view on this?
Well, thank you, and it's a great honor to be on this panel, so thank you for that. In my own experience over the last almost 40 years now, I think Indian arbitrations have evolved to a very large extent from the kind of claims that used to go to arbitration to what they are now. And that to some extent is because of the evolution of the business environment, which we've seen, particularly after 91, 92, and the international contracts entered into, the domestic contracts entered into, which are far more complex with the way industry has grown, business has grown. So looking back, a simple arbitration would be for recovery of money, for goods sold and delivered and a dispute raised, or a plant that's been delayed in its construction, where an arbitrator's role is important, but certainly not the complexity that is today in multiple contracts with parties, counterparties, with billion-dollar contracts, a lot of technology involved, complications in the engineering involved, none of which is easy to understand, in all fairness, for non-engineers and non-technical people. So I echo what was said earlier in terms of the process of trying to shortlist who the arbitral tribunal should comprise of. In India, the other thing I must add, and I think we've all experienced it more often than we would like, it tends to be a habit when the arbitrators, co-arbitrators are judges of a high court, they would like typically to have a presiding arbitrator who's a Supreme Court retired judge. And that seems to be a practice followed, or at least another high court judge. The chance of their appointing a practitioner is normally pretty low, or a technical expert. And it's evolved in this way for good reasons. I'm not getting into why, how, etc. So like I said, when we do have opportunities in a complex arbitration to represent a party, it is not unusual to check for all that we discussed, or Sherina and Manish discussed, availability. And when I say availability, meaning given the time a complex arbitration can take over a fairly limited period that we are now constrained with, rightly so, of the 12 and 18 months. And also the ability to actually understand the subject. So there is some element of information we've all got by seeing retired judges when they were judges in court, their approach, the kind of matters they heard, the kind of decision they've given. Counsel as well, the kind of matters they've done, how they approached a particular subject. But to answer the question specifically, and sorry to have gone around, I just wanted to give a background because I think it's contextual to talk to a potential arbitrator about not just availability, but also the ability to look at a matter of this kind and whether he'd even be willing to take on expert witnesses if required, including by appointing one or two himself, which can be very important in some kinds of disputes. So yes, we do have a brief discussion on the kind of matter. It is not unusual for the arbitrator when we ask for availability to also ask what kind of case is this. Parties, of course, because of conflict, and other cases they may be representing either on advisory positions or as arbitrators. Rarely are we asked in an ad hoc arbitration as to who the presiding arbitrator should be. Once the co-arbitrators decide on a particular person, they may, and it's not always the case, just ask whether we see a conflict for that appointment. But it's rarely more than a conflict. It's not usually a question of, do you think the person will be equipped or an expert in this particular subject? And on conflict, obviously, we have to give a good reason if we say there's a conflict, which does happen sometimes, but not too often. So in a nutshell, I think the universe has grown very well in India. The informality in certain stages, which is important, has come about, I think now much more than it was earlier, where there was a general gap, distance between a potential arbitrator and the counsel, certainly the party, who is not supposed to talk to the arbitrator, etc. So I think as it evolves more, the comfort we'll draw from the expert arbitrators, from their using experts in complex arbitrations, will be questions to be asked more and more in the appointments. And I hope also in the appointments of the presiding arbitrators as time goes on.
Thank you. There was a committee that was appointed for amendment to the Arbitration Act, and it has submitted its report on 8th of February. One of the recommendations that was made by the committee in a move to institutionalize arbitration in this country is asking the institutions to have code of ethics. So the LCIA must be having some practice directions or code of ethics. I want your views on that, Jackie. And along with that, what are the factors that are taken into account by the LCIA when sole arbitrators or presiding arbitrators are appointed?
Thank you. Let me start with this point, to the latter point, to sort of finish off the discussion of the selection of the presiding arbitrator. And I had to speak at some length when I started, because we started with the party-selected arbitrator, which in a way from an institutional perspective is a slightly awkward beginning. You typically are involved in the selection of either the whole tribunal or the presiding arbitrator or sole arbitrator. So many of the general comments which I made before are also, and perhaps even more so, relevant for the selection of a presiding arbitrator. So just to provide a bit more flavor, if you will, how does it really work? When the LCA selects the presiding or sole arbitrator, internally we do our due diligence. There is not a list of arbitrators, there's not a roster. We have a database, but we are not limited to that database. And we look at all these considerations that I just identified. We then come up with a long list of names which will go to the vice president who makes the actual selection. That doesn't have to be on the basis of that list, although often they will be guided by it. And I was pleased to see one of the vice presidents, Christopher Lau, just entering the auditorium in identifying which vice president is involved, or whether it's the president herself. We look, for instance, at the region that the parties come from, or the language skills, etc. I heard a lot already about some of the other characteristics. It's not just about what the clause provides, although that is the starting point. And you would be surprised to see how many clauses have very specific, very granular clauses. I know I'm not going to make friends with everybody on the panel when I say, as much as parties are involved in the selection of arbitrators, I think it is really the bread and butter of what an institution does to identify the best arbitrators for a case. And I think in terms of volume, of course, we see more than any law firm will see. We see hundreds of appointments every year, and we see many clauses with very particular and sometimes even contradictory or paradoxal characteristics. So that's what you start with. For the presiding arbitrator, I would say that applicable law is important. I heard Sherina's points about potentially being a bit strategic about this. I think as institution, when you have to find an arbitrator who will be presiding, not always, but it can be quite important to have somebody who is knowledgeable of the applicable law, because in all likelihood, it is going to be that arbitrator who will be drafting the award. Soft skills are also extremely important for a presiding arbitrator. At the LCA, in any event, we tend to require previous experience in LCA cases, in at least one case for a presiding arbitrator. It's not a hard and fast rule, but typically we will require that because it just makes everybody's life easier, in particular the arbitrator's life. If you've never seen an LCIA case, even if you've done an ICC or a SIAC case, there are always little differences in the rules and in the practice. So we tend to seek somebody who's done an LCA case before. We then look at the negatives, as I said. If somebody is too busy, and we're going to come back to independence and impartiality in a moment, but insofar as our own records have information about availability, we obviously include that. We do not at that stage do a check of independence and impartiality. That is different for emergency arbitrators. There we check conflicts before we present the vice president with a shortlist. We don't do that in all cases, otherwise it would just grind down the system, and also you would be potentially providing a lot of sensitive information to a lot of potential candidates. That's something that is often overlooked, but as an institution, if you start sharing with the whole world that there's a case between two large corporates and significant law firms involved, and you start calling up arbitrators, oh, would you like to be involved? And it's like, oh, actually, it's not on the record yet, but I'm going to be one of the counsel for them. So you have to be a bit careful about that. But profile is extremely important, and also looking at who is, picking up some of the points Sherina made, who is an arbitrator who will lead that tribunal. it's not just enough to be qualified on paper. And it's not only about having gray hair, but cementing the relationship between the arbitrators and making sure that both party-appointed arbitrators also get their say and that they are sort of taken on board. Anyway, we can talk about this more in the context of independence and impartiality, but these are some of the considerations. Now the issue of independence and impartiality of the institution. And I think it's an interesting one. It's also potentially a tricky one. I don't know if everybody has read the 130 pages of the expert report, which I did and which I found interesting. It has a very specific proposal that there shall be, I assume, a statutory requirement that the institution shall also be independent and impartial, and information about its management shall be disclosed. I think the latter is almost obvious. If you think about any of the large international arbitration institutions, you can find easily online how they are structured, who is on the board, who is on the court. All of that is and should be public information. The reality is that not always is it crystal clear who does what within an institution. So I remember a couple of years ago, we were considering putting somebody on the LCA board who had a particular role with a German institution where there is a court, but actually arbitrator appointments are done by a appointing committee, which is not crystal clear from the website, the paperwork, etc. So I think encouraging institutions to be transparent about their structure is, in my view, a good idea. But we should be careful not to throw away the baby with the bathwater and putting in very draconian and potentially requirements that are driven by practices in one country and extrapolating that and suggesting that for all institutions, whether they are Indian or French or English, the same requirements could be suitable, I think is being a bit ambitious. But looking at the rules, looking at whether there are guidelines for ethical standards of party representatives, ethical standards for arbitrators in rules is a good thing. But codifying it in a statutory rule may not be quite the solution that people would hope for.
Party autonomy is very crucial for the purpose of arbitrations. We speak of parties nominating arbitrators, and that's what we say, that the party has the independence here to have a neutral who is going to decide this dispute. I initially spoke about the crucial role played by courts in India in matters of appointment of arbitrators. Anand, what is your comment on the effectiveness of these appointments being taken up under Section 11 in India?
It's a mixed experience, to be honest. I think the preference often is of some judges to appoint a retired judge, of some to appoint counsel, of some for smaller claims to appoint a junior counsel, because he may have more time, the fees may be lower, etc. I think some courts are doing a fantastic job in terms of trying to get parties to give 2 or 3 names that they both agree on. And that's becoming a habit as well, where parties or counsel talk to each other, shortlist a few names. If they can agree to one, that's ideal at that stage also. But if they can't, it makes it much easier, I think, for the court to look at 3 names or 5 names and say, okay, both of you in principle are agreeable to these, so let me appoint one of them. Of course, it's done subject to availability, again, the same things we discussed earlier. In some courts, however, the delay in a Section 11 being heard has become a great difficulty, because by the time the arbitrator gets appointed in those courts, it could be many months. And I think that's something that needs to be looked at, maybe centrally or through discussions amongst judges. But that's a real problem when both parties are just waiting to start.
I have been asking myself this question: why is it only judges are appointed as arbitrators by the courts? For the past 1.5 years after my retirement, I have been speaking at various podiums outside this country also that it is time that the Indian courts should shed this habit of appointing only judges as arbitrators. There are legal professionals of various age groups who have experience in arbitration who should be appointed. There has been a change in the mindset of the Supreme Court of India as well as the High Courts, especially the Delhi High Court and the Bombay High Court, where legal professionals are being appointed. And there's also a refreshing change which I have been seeing in the arbitrations which I am conducting. I have bureaucrats sitting with me. I also have technocrats who have been appointed as arbitrators by parties who are sitting with me. They are as good as judges. To start with, I should tell you, forgetting about what the court is doing, even the parties think only of judges when it comes to adjudication of the dispute by arbitration, because they feel a judge would be impartial and he would be independent and he would be a better person to adjudicate this dispute. But as Sherina was pointing out, there's a serious problem. So you want efficient retired judges. I'm sorry to tell you, most of us don't have dates. So what do we do? So should we start looking for other people who have expertise in the field of arbitration instead of just sticking to retired judges? It's not an old boys school. So it's better that there is diversity on this aspect. As Anand was mentioning this, I thought I'll take the opportunity of speaking about appointment of judges. It shouldn't be only judges. It should be people who have expertise in that.
If I may add an element which a lot of people don't think of, the perception also is a challenge to a retired judge's award is less likely to succeed. And that's something people keep in mind as well.
I had an experience which I can share with you. There is an organization from Hyderabad which came to meet me. They said that we want arbitration clauses to be deleted from our contracts. We'll go to courts and then get our matters decided. I asked them, what happened? What's your problem? They said that judges are, retired judges of the High Court are being appointed by the High Court. And when we move applications on orders passed by the High Court judges, the district judges are saying we can't interfere against an order passed by the retired High Court judge. So Anand is right. So there is this problem, practical problem, but this can be solved by a recommendation that is made of training of judges at the academy in arbitrations. And apart from the mindset that, see, a retired Supreme Court judge is like a sub-judge now. If I'm sitting in an arbitration, if I decide an arbitration, in the other parts of the country where the high courts do not have jurisdiction, the award that is being passed by me or the tribunal in which I am there is challenged before a district judge. So it's not as if the district judge can say, what should I do with this award passed by the Supreme Court judge? I think slowly things will change. I want to move on to some other topic regarding gender parity. Jackie, what are the initiatives that are taken by LCIA to improve gender parity as well as other forms of diversity in the arbitral community?
Thank you very much. It's a big question and a big topic. In the 10 years that I've been with the LCA, we've seen an enormous improvement in the number of female arbitrators. And I'm very pleased to say that insofar as the LCIA selects arbitrators, we have now effectively achieved gender parity. That is an enormous milestone. We see that parties and to a lesser extent party-appointed arbitrators still lag behind. So the overall percentage of female arbitrators remains around 35%, but where the LCA itself selects, it is 45 to 50%. And that doesn't come easily because, as you may recall, I mentioned that the LCA is primarily involved in the selection of sole and presiding arbitrators, the heavier slots, where we want experienced arbitrators. So despite that, we are able to find female candidates. We also keep in mind that we don't want the same individuals time and time again, but again, we manage to overcome that and still end up with these good statistics. how do we do that? Well, it goes back to the procedure that I described, where the Secretariat prepares a long list of names that goes to the Vice President. That long list has to be diverse. There have to be women on the list. There have to be barristers, solicitors. We sometimes have academics or independent practitioners on it. There's nothing explicitly in the rule that prescribes it, but ever since I started, I made it quite clear that those internal lists had to be diverse. We are guided very much and confined by the clauses that we see, by the applicable law. So there are limits to what you can do, but certainly when it comes to gender diversity, it is much more doable to be creative, which is why it is slightly frustrating that in particular the parties are not quite with us. So we ensure that the vice presidents are fed good quality female candidates that they can choose from on the list. And it doesn't have to be somebody who is a retired judge or somebody of a particular age seniority, because the problem with the improvement in gender diversity is that if you go back 10 or 15 years, there were not enough practitioners necessarily in our business to find candidates. But if you're a little bit more creative and you look at the specialties involved, you look at the languages, you look at objective characteristics of the case, you can find plenty female candidates. But what we also do is ensure that when the LCA organizes panels, events, we ensure that there is gender parity in the lineup. We will not do events where there are only male speakers. We will make sure that if pictures are taken, pictures are circulated, you see pictures of both men and women. They're small things, but they do make a difference. In our correspondence, we use he and she. We don't just refer to him. So we really engage. We engage also with groups such as Arbitral Women, the ERAP Pledge. The ERAP Pledge in particular has been extremely effective in nudging people to be mindful of the importance of gender diversity. The challenge now is taking it beyond gender, which is a much more complicated issue to address. Your goals are not as easy. For gender, I've always thought life is very simple. Parity is what you're aiming for, but with other forms of diversity, even your aspiration is not as easily defined. You need to keep in mind both the applicable law, the nationality of the parties. You cannot quite equate race with nationality. There is religion. What do you do with religion? Is that something you're even entitled to distinguish, on that basis? So it's a much thornier issue. We have just appointed a diversity officer at the LCA who is going to be involved in external facing projects as well. For the moment, I think we tend to look at nationality almost as a proxy of wider diversity. So even if the clause stipulates English law as the applicable law, we really make an effort to make sure that non-English nationals are also considered and go again on that list that goes to the vice president. So these are some of the examples of what we do.
Thank you. There has been an increase in tactical challenges to arbitrators. What do you have to say, Manish?
Thank you, Justice Rao. Let me start by noting that although all major arbitral rules and national arbitration laws permit a challenge to an arbitrator on grounds of lack of independence and or impartiality, in any given case, you really have to consider quite carefully whether you're going to challenge an arbitrator, because you're always worried about the risk of the challenge being unsuccessful and having somebody on the tribunal that you might have antagonized. But that being said, at least in my experience, we do appear to be in an era of tactical arbitrator challenges. That doesn't mean that there are more challenges than before. but challenges seem to be taking much greater prominence in high-value complex disputes where the stakes are quite significant. And let me actually give you a real-life example. For several years, I was involved in an exit case for ConocoPhillips against Venezuela, arising out of Hugo Chavez's nationalization of ConocoPhillips assets. Our appointee on the tribunal was Yves Fortier, KC, and in this case, the respondent, it's all in the public domain, attempted to unseat him on an unprecedented 6 different occasions. After every single milestone, there was a challenge. And although each of the challenges was rejected, it caused a huge disruption and prolonged the arbitration. And one asks the question, what is driving this increase in tactical challenges? I have identified at least 5 reasons why there may be that growing tendency. As I said, not necessarily increasing the number of arbitrators, but just increasing this propensity for technical challenges. The first is that it's just a way of delaying things, and the delays can be quite significant, as was the case in the example I mentioned. Because once you make a challenge, more often than not, it will stall the proceedings. And if you're acting for the respondent and you're looking to delay, that can be one way of delaying matters. Again, as I said, it's not something that most experienced counsel will do lightly, but that I am now seeing with greater frequency that being used as a stalling tactic. The second reason why we may have seen this increase is that the arbitrator may just resign in response to a challenge. And again, there have been some recent examples where arbitrators have resigned, and they may well take the view that, particularly if the case is at an early stage, why create more trouble for the party that has appointed me? I might as well resign. And we can debate about whether that's the right thing or the wrong thing. But again, I've seen that with some arbitrators. The third reason is that sometimes these arbitral challenges are successful. And we'll talk about standards of independence and impartiality, but they tend to be nebulous. And although some attempts have been made in the IBA guidelines on conflicts of interest to harmonize the standards, they are not always very clear. Their practical application in particular scenarios may not always have been envisaged. So again, sometimes counsel may well say, let me try my hand and see how things go. Fourth, and this is perhaps the most technical of reasons, is sometimes the parties think that, look, I might actually affect the psychology of the arbitrator by making it very clear to the arbitrator that we are watching you, and it may be that by that challenge, you, particularly with an inexperienced arbitrator, you might influence their psychology such that they spend the rest of the arbitration trying to prove to the counterparty, if I could use that terminology in that context, the party that didn't appoint them, that look, I am independent and impartial. So that is also, that psychology can also drive tactical challenges. And finally, again, with not very experienced arbitrators, you find that some parties might challenge simply to evince a reaction from the arbitrator that then becomes the basis on which the challenge is sustained. Because if you as an arbitrator react quite aggressively in response to a challenge, that can itself cast doubts about independence or impartiality. So again, these seem to be some tactical considerations that are driving this increase. Now, again, I'm not endorsing the merits of those, but I'm seeing them with greater frequency in practice. I will just conclude by noting that when you are the party that has appointed an arbitrator who's been challenged, you also have to then think about what you're going to do. Because you're obviously looking at the cost and delay, you're thinking about potential challenges to the awards. Is this going to become a stumbling block in terms of recognition and enforcement of the award? And particularly if you're at an early stage, is this something that you can just remedy by appointing somebody else? In most often than not, I think you will resist the challenge, particularly if it is frivolous, if it is tactical, if it is based on the considerations that are identified. But again, you have to really very carefully consider whether you're actually going to fight it.
Thank you. Section 12 of the Arbitration and Conciliation Act 1996 obligates an arbitrator to disclose all circumstances that would give justifiable reasons or doubts about the impartiality and independence of the arbitrator. And we have included 5th schedule and 7th schedule, which is the orange list and the red list from the IBA guidelines of conflict of interest. Has it made any difference, Anand?
I think it has made a huge difference on 2 counts. One, the conscience of the person who's accepting the appointment upfront. But I think as important, if we do find something going wrong, our ability to point to a provision rather than having a general challenge based upon certain set of facts. And we had a situation, and as I repeat what I said earlier, the universe of well-known arbitrators in India is quite small. It is growing, but it's quite small. And there's a fear in many people that if you make a challenge in a particular case, there may be a repercussion. Maybe it's an unfounded suspicion, but there may be a repercussion in another case. We actually had a situation where a particular eminent personality, I won't name him, did not disclose something he should have disclosed under the requirements. We had no idea, sole arbitrator, but we found on a section 17, the behavior seemed very odd to us. So we made some investigations and found out the aspect of non-disclosure. The question became, now do we challenge? Technically we can't. Do we have to wait for the award to come? So we actually wrote a letter to the arbitrator and said, look, with a copy to the other side, that this is what we have found out. It should have been disclosed. In case we are incorrect, let us know. In case we're not incorrect, we'd rather have you withdraw. He did not. We took a chance and filed a challenge in the court. It may have failed, but he then withdrew. So I think also from a community, we need to bring about the awareness that while it's in the schedules, it's great. But we need to call out, I think, when required, whoever the person may be, maybe first politely, privately, and not make it public. But I think that maturity should come in sooner rather than later. And that will help a lot in credibility of the arbitral community in India.
Thank you. Jackie, what are the LCIA rules and practices in terms of arbitrators' disclosures and challenges?
Again, a big question, but picking up some of the themes that Manish and Anand referred to, it's interesting. The LCA actually has seen very, very, very few challenges. In 2022, we did not have a single challenge. And last year, I think we had a handful, and we're talking about 300 to 400 arbitrations per year. So first of all, I think we should make a distinction between investment arbitration and commercial arbitration, both in terms of publicity, but also I think in terms of the nature of the challenges that we're seeing. So at the LCA, we typically have commercial cases, often involving states, but commercial cases. Having said that, I think the reason why we have so few cases is because of the robust disclosure system and because of the robust challenge procedure. And that may sound like a paradox, but we do flush out issues at the outset. We're quite strict when it comes to the information that we require. And I already referred to independence and impartiality on the one hand and availability on the other hand. They really do go together. So potential arbitrators who are approached in a case are invited to fill out a form that has very specific questions about the number of cases, the number of awards that are outstanding. We ask them how many cases they act as presiding arbitrator versus party-appointed arbitrator, because that makes a difference in terms of workload. but also the cases where they potentially have a conflict. The basis under the LCA rules is related to the unsocial standard circumstances likely to give rise in the mind of any party to any justifiable doubts. So you are requested as arbitrator to put yourself in the position of the parties and say, from their position, is there potentially something to disclose? That is not the standard for challenge. That is a third-party test, but for disclosure, you go further and you put yourself in the shoes of the parties. What we don't have, unlike the Indian legislative system, is a list in the rules or in our guidance notes of circumstances that we say should be disclosed. We thought about that, and we were and are of the view that is too rigid a system. As an international institution dealing with an enormous range of cases, it is very difficult to cast in stone the types of conflicts that you want to flush out. We are guided by the IB guidelines. We never used to say that explicitly, but we now do. And as we know, they are changed from time to time. Only yesterday, I think it was officially published that they have been updated once again with the input of the LCIA, and that's an important building block, but it's not everything. I remember years ago being involved in discussions about whether it was suitable in India to have a list in a schedule to the Act, and I actually came out saying, yes, I think it's a good thing given that a change was required. And maybe to be a catalyst, it is helpful. But I think once you go beyond that and you need to keep in mind whether you have insurance cases or maritime cases or generic commercial cases with American parties, Indian parties, just having a single list of situations that are disclosable, I think is not helpful. Now, as to the challenge procedures, why do I think that they contribute to the lack of challenges? LCIA challenge decisions are reasoned decisions. And I speak with experience. In a long gone past, I was challenged myself in an LCIA case, in one of the very few, thanks to the activities of the presiding arbitrator, I should say, but the entire tribunal was challenged, and it really illustrated to me vividly what a robust procedure it is. It's almost like an arbitration procedure. And I'm happy to say it had to do with availability. That case went away. But you get a committee of 1 or 3 court members or retired court members who will review this almost as an arbitration, hear the parties, sometimes even have a hearing, and quite importantly, it leads to a reasoned decision that is shared with the parties and which is subsequently published. We let a few years pass before we publish because we don't want the case to be still active, and it is, of course, on an anonymous basis. And it gives insight in the kind of cases that are leading to challenges. Even though we have very few cases, there are even fewer cases that are successful. So I heard Manish rightly say there are successful challenges, but there are very few and far between. And finally, and this goes back to the involvement of the court, under English law, and many of our cases are seated in London, you can go to court to seek a challenge, even if and when the institution has already decided on the challenge. But very helpfully, in recent case law, it was confirmed that if and when it is the LCIA court that has looked as a challenge, the English courts won't really second guess the decision of the LCA as an institutional challenge decision maker, because really the procedure is so robust that the court will generally say, we accept that as an adequate procedure. There is always the right to go to court, but in that sense, we are not too worried about tactical procedures. And I think that may be quite different what I read again in the expert report about the concern here that even if there is a decision, certainly by co-arbitrators, that there will be a Section 34 procedure. I think in the English context, with the robust LCA procedure, we're not really seeing that. And I'm obviously grateful for that.
Thank you. Sherina, when you were answering an earlier question, you were speaking about the availability of an arbitrator being an important aspect that you would take into consideration when you make a recommendation. What are your views on the recommendation that is made by the committee that there should be a cap of 15 arbitrations insofar as an arbitrator is concerned?
Thank you, Justice Rao. I obviously recognize the ability to devote sufficient time to the arbitration, and that is, of course, crucial for ensuring transparency and fairness in the whole arbitration process. And in fact, I was looking at some data from 2022 in India, and that actually shows that there's actually, for the number of pending arbitration cases in India, a majority of around 48% were actually pending for a year, and around 23% were pending for 10 to 20 years. So that's quite a number when you look at 23% pending for 10 to 20 years. And therefore, I think the question really is, will limiting the docket of an arbitrator, is it a prudent step? So let's look at the positives. Of course, there are positives to this, and I can understand why the expert committee came up with this idea because of the backlog of the courts, and also, this will definitely target the backlog created by arbitrators who are sitting with heavy caseloads, which is also then leading to the delays and undermines the efficiency of the entire arbitration process. And I think what's also helpful is the provision that has been recommended that parties can actually waive this restriction through an express written agreement. And therefore, again, it puts it back with the parties. And I think that's going to be really important for this clause to actually work. But there are a number of potential considerations or negatives. I would say considerations that need to be bear in mind. One is, why the number 15? There's no data to tell you that 15 is the ideal number. It could be 20, it could be 30. What tells you what's an ideal number is actually the person themselves, because they know their caseload. They know what is going to be, whether they're sitting on a very, very complex arbitration, and then it shouldn't be 15, it may be 3. They will know their caseload. So is it complex, what they're sitting on? What is the phase of the proceedings of the other matters that they're sitting on? And what is the attention to detail? Every matter doesn't need you to read every word and every sentence. So again, it comes down to the individual, but I get it that the restriction is there because sometimes individuals don't have that restrictive power on themselves. And therefore, there is some sort of guidance that 15 should be the limit. But I think it really comes down to what is the person sitting on, the complexity of what they are sitting on, and the phase of the proceedings as well. And I think also, obviously it imposes a restriction, can impose, the prompt arbitrators to be selective as well, because I think sometimes people can say, well, I don't want to do this case. I'm just because I have this number 15 looming over me. They will start getting really selective about the kind of cases they have. And it also might alienate people who actually have the real expertise for a case. Like, say you want someone who's really good on solar, and that person says, well, sorry, I've reached my number 15. I can't take on your case. That's going to impinge the expertise as well. I'm not saying there's only one person who's great in solar. I'm just saying it's going to reduce the level and the expertise as well of the person. And I also think one needs to take into account the modern world where we have AI and technology. Again, does that feed into the number 15? I mean, we're 5 of us on the panel here. two sitting with iPads. Kevin Nash was sitting with an iPad. There's so many people in the audience sitting with iPads. That is leading to a lot more efficiency and AI as well. So I think, whilst it is laudable that the provisions have come in as being suggested, that's great. But I think you just have to look at it with caution. And I think probably in 2 years' time, if this does come in, we will actually look at hard data and see how it's actually worked in practice.
Thank you, Sherina. Well said. And I have something more to add, that 5 might be more for some people and 30 might not be enough. As per the provisions of Section 13 of the Arbitration Act, a challenge to an arbitrator is not appealable. That point can be taken only after the rejection of the challenge when an application is filed under Section 34 for setting aside the award. The committee has now recommended an appeal against an order passed rejecting a challenge to an arbitrator. Manish, what are your views on that?
I think the committee identified 2 reasons for recommending this reform. First, they were concerned about challenges to an arbitrator being decided by the arbitral tribunal itself. And the second concern was that, if you are before, and let's say the tribunal rejects the challenge and you then have to wait for the award to be rendered to challenge the award on the very same grounds. While I agree with the concerns, I'm not sure if I'm not sure if the committee has gone far enough in terms of recommending the reform. In my view, in India, there is a real opportunity to actually streamline the process, because you're trying to balance 2 considerations here, right? You don't want to have a full-blown arbitration before a tribunal where a party feels that, one of the members of the tribunal are more obviously biased. But at the same time, you have to guard against frivolous challenges before national courts if you permit such an appeal. So I do wonder whether in the Indian context, one way to address it would have been to say that in the context of an institutional arbitration, where an arbitral institution will determine a challenge, that will be final and binding. So a slight deviation from the English context, where, as Jackie said, in any event, institutional decisions are given a very high degree of deference. But I wondered whether in the Indian context, they could have said no further challenge to a court where an arbitral institution has already determined a challenge. And maybe in the context of an ad hoc arbitration, you could have this interim interlocutory judicial review, but on very limited grounds, so that you don't then have frivolous challenges being brought before national courts. But those are my views.
Thank you. Unlike in London, every award is taken to court in India. And courts have been all the time trying to make India an arbitral-friendly jurisdiction. So many things have been suppressed because there is a complaint against the interference by courts and delay in courts being the main problem for arbitration not improving in the country. Now, the recommendation that is made, I'll express my view on that there is an appeal that is provided against an order rejecting the challenge to an arbitrator. I'm sure that every order is taken to the court now. That's an appeal under Section 37. If I'm a lawyer, I go before Justice Prasad or Justice Rekapalli and then argue that this is a question of jurisdiction. Unless you pass an interim order, the arbitrator will proceed with the matter. What is the use of my petition? They would also be thinking that it's better that we stay the order. And once there is an interim order and the matter is pending in the court for the next 2-3 years, very difficult to get that order vacated or that matter heard in view of dependency of matters in court. Again, we are going back to where we started. So limited grounds of judicial review, Manish, even for Section 34, the Supreme Court has been repeatedly saying that these are the only grounds which are available to you for interference. But the courts are alert now. They don't entertain, especially the Delhi High Court. I'm told that if 34 petitions are dismissed at the admission stage when they don't find any ground, 37s are not entertained. Supreme Court anyhow is staying its hands off. But there are two views about that, providing a challenge. And one thing which I should tell you in my personal experience is that not many instances of challenges are there, even in India, insofar as 13 is concerned. On 16 years, where the jurisdiction of the tribunal is challenged on competence principle, the tribunal decides it. Thank you so much. We have 10 more minutes, and the panel will be taking questions. Good. Shivans?
Good afternoon, everyone, and thank you to the panelists for a very insightful session. So my name is Sadaf Habib, and I am an independent arbitrator, not an ex-judge, but yes. I have a question for Jacomijn, actually, and it relates to the gender parity that you mentioned, because you said, I think 45% have been female appointments. What I was curious about is, out of the 45%, how many have been first-time appointments?
I don't have the precise numbers in my head, but we do look at every year when we look at our statistics, we try to see if there are other relevant features in our cases. And repeat appointments is obviously an issue that we keep in mind. I refer to the fact that where the LCIA selects, we typically do not select somebody more than twice a year. And that is also true for women. What we have noticed is that where the parties and the co-arbitrators select female arbitrators, there is a higher proportion of repeat appointments. So not for the LCAA court selection, but certainly for party-nominated arbitrators who are looking to select a chair, it is kind of inevitable that they look at a fairly limited pool of arbitrators, because intrinsically what they will be looking at is people that they have sat with. So it's very difficult to, in a way, increase that pool. And that, to some extent, goes to explain my reluctance about the whole structure of party-selected arbitrators. I don't think you can avoid that problem so much. But for the LCAA itself, there is not a significant deviation between the number of repeats for men and for women.
Yes.
So I'm Mohit Jolly. I'm a counsel at the Delhi High Court. My question is in the Indian perspective, particularly to Justice Rao and Mr. Desai. Like we are moving into the time-bound regime of the recent amendments to the Arbitration Act, we moved into a time-bound decision of arbitrations. Should efficiency and availability be a ground for included as a ground for challenge or to the competence or the procedure of the arbitrators?
Efficiency, I think, is mentioned in section 14. If you have seen, the mandate can be terminated on that ground. I think that's what section 14 says, but that being provided as a ground for setting aside arbitrations, can I give you my own experience? It's only people practicing in the High Courts and Supreme Court who appear before us. And adjournments are sought as if they're asking for adjournments in court. Last minute, we get letters saying, please adjourn the matter. Pleadings are not completed within 6 months, which is the time that is fixed by the statute. There are requests for extensions galore. And thereafter, when it comes to cross-examinations, a cross-examination of a witness goes on for a week. So I can go on telling you about so many problems that the arbitrators face insofar as completion of the arbitration within the time that is fixed by the Act is concerned. I'm not very sure whether that should be done, but it needs the assistance of the counsel as well as the arbitrators to ensure that the arbitrations are completed within time, instead of going to court for every arbitration and asking for extensions. But I'm not really sure whether you can make it a ground for setting aside the award. Anand, do you have to say something on this? I have a co-arbitrator agreeing with me.
No, I think what you said absolutely valid. It's a ecosystem which has to work together. So just blaming an arbitrator or a tribunal is not, to my mind, an answer.
Yes.
I'm Shlok Chandra, practicing advocate. My question is for Justice Rao. So as a presiding arbitrator, is an attempt to build consensus when the other two arbitrators have divergent views, which are mirroring the views of the parties that have appointed them. And if one of the other arbitrators is seeking a concession on, say, the quantum for having consensus, is that desirable to have that consensus in that case?
This is one area where I feel having been a judge is really helpful. Because sitting in the court, you have two judges with you, and then almost on a daily basis, we keep discussing about exchange of views. So the other judges might not be in agreement with what I say, or one judge might not agree with what I say. But there is no nomination. So all the judges are impartial. They do not have any pressure of being nominated by a party. When it comes to arbitrations, I have been really going through this problem, which I have already expressed to co-arbitrators taking a stand in favor of the party who have nominated them. It is becoming difficult, but ultimately I see the benefit of sitting with colleague judges. Ultimately, they see that they cannot push it too far. So they might be definitely canvassing the view of the party which has nominated them, which also I feel is not desirable. But ultimately, I've been finding ways and means without serious problems of an order being passed by one party. There are actually benefits of this. You get different views from parties, and then the reflection of views would definitely help you in taking the correct decision.
Hello, I'm Aditya. I'm a counsel as well as an independent arbitrator. My question is to Justice Rao. My question is, sir, do you feel that an arbitrator should have greater powers of contempt as they exist in the present times, so as to ensure decorum, especially for younger arbitrators like me?
You know, section 27 of the Act.
27(5) is there, Your Lordship,
at least we can go to either Subramani Prasad or Pali, who has gone, and then ask them to punish people.
But for maintaining decorum during evidence, etc., I believe that section is slightly inadequate.
The contempt of court is an old relic. Actually, you know, as counsel, Aditya, and then there are so many other advocates who are not in favor of Contempt of Courts Act. And there are complaints that even the courts have been exceeding their limits while exercising their power under the Contempt of Courts Act. At least we have this liberty of telling the court that this is what has been happening. We see that there are so many undesirable things in arbitration. People take liberties, but we'll have to face them. I don't think tribunals should be given the powers of contempt. It's not only the arbitral tribunal, even the statutory tribunals do not have this power of contempt of court. They'll have to go to a court of record, which is the High Court or the Supreme Court. Yes? Radhika, any more?
Somebody, can I ask a question?
Yes. Yes, please.
Yeah.
Sangeeta.
I'm Sangeeta, yes. My question is to Justice Rao. I'm taking a cue from what you said, that why are lawyers not being encouraged to be appointed as arbitrators? As far as our Delhi High Court is concerned, we have a lot of appointments where lawyers are getting appointed. My concern is that those are very low value disputes. I think we have extremely competent lawyers in the Delhi High Court and Supreme Court. So why is the trend not, why should it not be changed? Why should high value commercial disputes not being referred to lawyers as arbitrators?
I totally agree with you, Sangeeta. To the chagrin of my colleagues who are retired judges, they don't like my saying that lawyers should be given. Then they say that we would be unemployed or underemployed. There's so much of work in arbitrations. I find the diaries of all my colleagues full. So the next 2-3 months, there are no dates for most of the retired judges with whom I've been sitting. I totally agree with what you said. After my retirement, I've been attending various conferences. I've been meeting youngsters, especially youngsters from India, who have gone to London, who are practicing in Singapore, Dubai. I've even gone to Seoul and then saw some youngsters. They're doing extremely well. They have been there for about 10 years, 15 years. That would only showcase the talent that is available in India. Youngsters in India who are specializing in arbitrations, they should be the persons who should be given arbitrator appointments. You need legal knowledge, definitely. So why restrict it to a judge? Not necessary. In an arbitration, you don't need a judge. There are arbitrations where you need experts. There are arbitrations where lawyers would do much better than judges. I agree with you. I have also been experiencing something which I thought I would share with you. We in India are seen to be persons who are not competent. I do not know why this misnomer. And we regularly are told that there is so much of improvement that you have to make. I looked at the statistics of SIAC for 2022. For about 380 appointments of arbitrators, there were 14 Indians who were appointed as arbitrators by SIAC. It's not as if all arbitrators in India are useless. It's not as if they are persons who are inefficient. And you also look at the parties from India, 2 parties going to Singapore and then getting their dispute decided. This is because we do not have good institutions, number one. And number two, this is also because they're afraid of delays in courts. That might be one issue. But you would also see that law firms in India go out and then they appoint only arbitrators from outside. Unless we are also given an opportunity, how is it that we would show that we are also good enough? So I'm not saying this for the purpose of trying to get work for arbitrators in India. Definitely not. So let me not be seen to be doing that. But I'm only telling the youngsters, see, we are over the hill. The future, what has to be looked at is how arbitration is going to be in the next 20 or 30 years. So there are efficient youngsters who would definitely match the best in the world. So wake up, youngsters. So you are really good. It's just a question of you are getting an opportunity and you're going to get it.
We'll take one last question. Sir.
Good afternoon. My name is Siddharth Yadav. I'm a senior advocate. Since the topic is selection and challenge of arbitrators, my question will be to Mr. Desai and Ms. Petit. Mr. Desai mentioned that sometimes arbitrators, the nominee arbitrators of a party, are nudged, or every panelist has said that they take sides or are inclined. So my question is, has there been an occasion where even nominee arbitrators have been recommended or nudged to appoint a presiding officer arbitrator? Do you even do that? Because then that hinges on the fact of selection and challenges to the arbitrators. So we are not only on the arbitrator, we are also on the presiding arbitrator. Has there been an occasion on that as well? So both, because you both run very successful law firms, so I'm putting this question to both of you, please.
So let me put it this way, starting with the client. Clients are dying to have an arbitrator who is their man in India. That's the reality. We have to push back as a law firm or as a counsel to say, look, it doesn't work that way. As Justice Rao said, once appointed, there's an obligation to be impartial. That's a reality, and we, at least as a firm, I can assure you, maintain that very strongly. But there is a discussion, often, not often, but sometimes, about the aspect of availability of a presiding arbitrator, because if they are retired judges, as Justice Rao said, they can be extremely busy. Issues regarding the familiarity with the subject, if it's a technical subject, which is also important. And finally, whether he's conflicted in some way, either having decided that point as a judge, which people perceive to be a possible area of bias. Are these regular occurrences to talk about it? No, but it does happen at times. Again, you know, the very complex cases, the care to be taken is far, far higher. You know, there are billions and billions of dollars involved, to huge companies which have huge legal departments. It's a critical aspect for them. It's not as easy as simpler cases. And that's a reality which we have to live with.
In my experience, that's a really good question. In my experience, I don't think there's a nudge, but there is definitely, if the parties decide that actually they want a bid to decide who's the presiding arbitrator, then there are times where I've asked for the clause actually to be varied for the two-party appointed arbitrators to seek, to discuss with the parties that's selecting them, and consider names. And then that comes into a point Manish made about the rank and strike system. And we've done that very successfully. We do not discuss the merits or anything. We actually, we don't have any communication with the chair, but you would have communication with your party-appointed arbitrator, and the two-party appointed arbitrators talk to the council that has selected them, not on merits, but on the qualities that maybe they'd require in the chair or on the names of the chair. And maybe each side will put together 3 names each. You'll whittle it down to say 5 names, and you'll have the rank and strike system. So, but it's not, as I said, it's not the nudge, but it is very much a consensual process. So that is something we deploy quite a bit. One of the other points I did not make, which I think is relevant as well and quite practical, is, and particularly I see that a lot with parties from India, where, say, we are considering selecting a chair or a party-nominated arbitrator from, say, the UK, and people from India haven't had that exposure to that person or to the jurisdiction sometimes at all. We do something which is called a parade of arbitrators, where, and again, this is where the parties from India get to, or from whichever part of the world, if they don't have any, exposure to that other jurisdiction where, say, a party-nominated arbitrator is going to be chosen from, then there's 5 people that are selected, and we organize a tea with that person or a coffee. The merits of the case are not discussed, so we are very clear, and we as counsel are in on that. We do not discuss the merits, but it gives that comfort for the person whose dispute it's going to be to have that tea or coffee with the person, and it's a general discussion. And the person is well aware that they're being considered to be appointed as an arbitrator. And that is something that actually we see quite a lot now in practice. And many a times arbitrators will make that disclosure that they were part of the parade. No merits were discussed, but they were assessed in that way. And so that's also something practically to be considered as well. And touching upon another point that Justice Rao made, we as Indians are very much as good as the rest of the world. And taking that into account, I've actually drafted the India Promise, which was touched upon by the Chief Justice yesterday in his speech, which I'm going to be rolling out. And it is very much exactly on the point. Looking at the statistics of the different institutions, we as Indians are not sitting as arbitrators in international disputes. And with that, I have written the India Promise. It's actually borrowed from the Africa Promise for looking at Africans being appointed in international arbitrations, not just on Africa disputes. So hopefully this is something, again, it's a voluntary thing to sign up to, and that's something we will be rolling out in India as well.
Thank you very much. This brings us to the end of this session. Thank you for such an engaging session, and we do agree with your views, sir. We need more young arbitrators to come forward. May I now request Honorable Mr. Justice Subramaniam Prasad, Honorable Judge, Delhi High Court, member of the Arbitration Committee, Delhi High Court, and the member of the Organizing Committee to please come onto the stage and felicitate the speakers. Please give a huge round of applause. Thank you, everyone. We'll now be taking a 5 minutes break, and we'll request you all to then be seated and be back for the next session. Thank you.